Good afternoon, everyone. Allison Skyberg here, Consolidated Planning Group. We are happy that you have joined us today for this webinar. We are here today with attorney Anne Shevlin. She has a law office in the San Antonio area, and today we're going to be talking about turning 18 and legal options for parents of special needs children. We've got more slides today than we probably will ever get through, but we kind of did that on purpose because we want to give you the information. So today we are in webinar mode, which means that we can't see you or hear you, but we know you're there and we're glad that you're here. And our chat box is open today, so feel free to put your questions in the chat box. If you emailed your questions in or submitted your questions ahead of time, we have those and we're going to address as many of them as we can today. A lot of the slides are going to address some of those questions. I'll be monitoring the chat box and we'll be reading those questions to Anne today. And if you have questions that didn't get answered today, then feel free to reach out to Anne directly, and her contact information will be out there as well as myself. So having said that, I did mention we are in webinar mode. This is being recorded, so everybody is going to get a copy of today's slides and a link to the recording. A lot of the stuff that we're talking about today, it's a lot. And if you've ever felt overwhelmed as a parent when you're kind of feel like you're drinking from a fire hose with this, you're not wrong. And each one of these things that we're going to talk about today honestly could and often does have its very own webinar for that specific topic. So if you hear something today and you need to take a deep dive into it further, we probably have a webinar on that on the Consolidated Planning Group YouTube channel. The Consolidated Planning Group YouTube channel you can subscribe to for free. There are over 500 webinars on planning for special needs. If you can think of it, we have probably had conversations about this. So, and we've tried to title those things intelligently so you can kind of search for the step that you're on in the planning journey. So for those of you that are joining us for the first time, welcome. We are so glad that you're here. And for those that have been attending for years, we're certainly glad that you're back. Consolidated Planning Group is a holistic special needs financial planning firm. We are in Sugar Land, Texas, but we serve families all across the United States. We have over 30 years of experience. We're nationally certified as Social Security advisors, chartered special needs consultants, and members of the Special Needs Planning Academy. So we stand ready to help you plan for the future of your loved one with a disability. What we do is different from what Anne does. Anne doesn't do what we do and we don't do what she does, but we often work closely together. So I liken that we're the money, she's the paper, we're the money. Okay, the legal documents, they're so important, you have to have them. But how much money do we need to fund a special needs trust? Who's going to care for your child when you're gone? What kind of housing options do we need to look at? How and when should we apply for public benefits, and what might my child or loved one qualify for? We help with all of those things. So we suggest, whether you work with us or you work with Anne, we suggest that you do work with a professional that is specifically nuanced in planning for special needs. There are a lot of financial advisors in the U.S. Fewer than 0.1% have any background in special needs. There are a lot of attorneys in the U.S., but not that many are working specifically with special needs. And so it's so important that your legal documents are right. It is so important that we have money in the right buckets to preserve eligibility for state and federally funded programs. And that is why you want the right professionals on your team. And having said that, you guys may have heard me say this before, there's a lot of things in your life that can be a DIY project, But when it comes to your legal documents and planning for a loved one with a disability, we do not suggest doing it yourself. We do suggest working with professionals on that. At Consolidated Planning Group, we help people put protection plans in place, lifetime care plans. We do a lot of transition planning. We help establish ABLE accounts, and we do a lot of advocacy by way of our webinars. So when it comes to planning, we want you to be thinking about things. One thing that I think about is think about how you want your future to look. Our future in retirement looks different than that of a family that's kids are all neurotypical and go to college and sail off into the sunset, get married and have kids, etc. if we have a kid that's going to have care needs the rest of their lives, careful consideration and planning goes into that. So developing a future care plan now while you're of sound mind and body, and not waiting until a medical event or something happens, some accident or something like that. Thinking early about post high school educational and vocational options, touring, transition programs, partial care, full care, residential programs. Getting your names on lists doesn't mean that you have to say yes, but it gives you the right to say yes if you come up on that list in the future. And we also, warn against we advise to make careful considerations before naming a sibling as a future caregiver. They might be the successor trustee of a special needs trust that's going to pay for said care for your loved one. But I always just think about our other kids have hopes and dreams. Maybe they want to go to college. Maybe they want to have a successful career. Maybe they want to get married. Maybe they want to have a home. And maybe that is in line. Maybe they have their own kids with disabilities, and it could be challenging. So we always just like to say, it's not to say that family doesn't take care of family, because they do, but we like the siblings to have options as it relates to providing care for their loved one in the future. So having said that, I am going to turn everything over to Anne, and we're going to get started. And like I said, please feel free to put your questions in the chat box, and we'll get to as many as possible today.
Thank you so much, Allison, and welcome to everybody who is able to tune in today. My name is Anne Shevlin. I am an attorney here in San Antonio. I am a special education advocate, a family law attorney, and also a guardianship attorney. So I have sat in many of the same ARD meetings that you all have sat in, where you are warned by your special ed team that your child is approaching the age of 18. Adulthood is coming, and so they're normally asking you to go forward and put some sort of plan in place, either for guardianship or some other sort of assistance to help your student make decisions as they turn into an adult. And so I wanted to take some time today to discuss with you exactly what that means, what your legal options are, and how to move forward. So of course, the first option, this is not one I recommend, that's to do nothing, right? And unfortunately, a lot of people do that. But what normally happens in that case is I will get an emergency phone call, because eventually that option doesn't work very well. Another option is to enter into a supported decision-making agreement and to have powers of attorney in place. And what that is when your student signs an agreement saying that they are asking for you to assist them in making decisions, but it short circuits the guardianship process, so you don't have to actually go through the full legal probate court system to put those documents in place. The full, most comprehensive option is to put a guardianship in place. We do that through probate court here in Bexar County. And there's two different types of guardianship. There's guardianship of the person. That is the option that we use for individuals that do not have an estate. So if they don't have their own financial resources, guardianship of the person will work. If not, we'll do guardianship of the person and the estate, and that allows us to make financial decisions as well. The special needs trust works hand in hand with guardianship, and so that is a way to shelter assets so that you do not affect eligibility for SSI and other need-based programs. And so that is definitely something that should be considered as we're deciding which option is best for your family. Another option is to just use the representative payee program, which is through the Social Security Administration. There are some benefits to doing it that way, but we'll get to that in just a minute. In terms of, on the next slide, we're going to show the pitfalls of doing nothing, right? So if you do nothing and you just cross your fingers and hope for the best, the issue that comes up there is that your student is going to have complete authority to make their own decisions, right? And so if they start to make decisions that you think are not in their best interest, there's nothing really that you can do. They can make their own medical decisions, they make their own educational decisions. If that means that they decide to drop out or not attend any school programs anymore, there's nothing that you can do about that. Same if they choose to not have you involved in medical appointments, you are not invited into the examination room to meet with doctors. And so that's normally the the worst of the choices, right? The next step forward on the next slide, we'll talk about supported decision-making agreements. What that is it looks a lot like a power of attorney. They're going to sign over that they want your assistance in making decisions. It's very easy. It looks a lot like a power of attorney. The student is going to check boxes on what they want help with, right? If they want you to help with school decisions or medical decisions, they can check that off. They can check off that they want you to have access to their medical records. So it's basically a HIPAA release form. Um, that works very well for a lot of families. Where it doesn't work is if you have a youth who may not want you to be involved, right? It's revocable by either party. So if at some point your son or daughter does not want you to be involved anymore, they can tear that agreement up, right? And so at that point, are back to the doing nothing category. You don't have any legal protection there, and there is no court supervision for that. And so um, I would be careful if you decide to go that route. Powers of attorney, yes,
I just wanted to say with the supported decision-making agreement, we've seen a lot of this and we do serve people all across the United States. Not every state has a supported decision-making agreement. Texas does. A lot of states do. But usually we see that supported decision-making agreement going alongside of the power of attorney and healthcare power of attorney, HIPAA release, that kind of thing. And I'm sure that you're going to talk about that. But one thing that I wanted to just bring up, because I have seen it as a repeated problem, is that in a lot of states, Texas is least restrictive, most appropriate for the ward, is the language. So the least restrictive, most appropriate for your loved one is what is the right route. And then some people have taken that to the extreme of that everybody should have a supported decision-making agreement, power of attorney, and healthcare power of attorney. And I just wanted to warn, I'm not pro or against. I am for what is appropriate for the individual. And I think it's important to be thinking that way because if an individual does not have capacity to understand what they're signing and signing a power of attorney, healthcare power of attorney, HIPAA release, supported decision-making agreement, then there's issues with that as well. So I want you to address that.
yes, and I agree with you. So just like for a power of attorney, same with supported decision-making agreement, whoever is signing that needs to have the capacity to understand what it is exactly that they're signing. And so it may not be appropriate in every case. I would say that if you have someone who is very high functioning on the autism scale or has a slight intellectual disability, they're able to understand, but maybe not able to make very detailed financial decisions or to really understand more complicated medical situations, then a supported decision making agreement may be the way to go. If you are in a situation where capacity is very low, this is not going to work in a situation like that.
So in general, capacity and IQ, and there's not a magic number for Texas, right? The magic
Correct.
number of intellectual disability in general is an IQ of 70 or below. So if we have someone, there are plenty of people that have an IQ of 70 or 75 that may have capacity and may not need a guardianship or a partial guardianship. But there are also other people that may have an IQ in the 80s or 90s or even higher than that that have severe mental health challenges or other reasons that do make it necessary to have some, sort of guardianship in place. So I just want to advise that it's just really not a magic number. But the other thing I wanted to say here, Anne, is, we talk to a lot of clients and, they're nervous about this. You got a kid turning 18. They've had guardianship all their life and now they got to apply for guardianship. They got to go to the courts and all this stuff and they're taking rights away. They're nervous about that. They may have a kid with violent tendencies and they're afraid if they're under guardianship that they'll be responsible for something ridiculous that the kid does. And they're so nervous. And what I like to encourage people is to have a conversation with the attorney because and you're going to sit down with the family. You're going to talk to the kid. You're going to talk to the parents and you're going to go over what their options are and lead them to what might be the most appropriate and least restrictive for their loved ones. So I always tell people you don't have to know what you need when you go sit down to have a consultation with an attorney. You're there to help.
No, that's very true. And oftentimes I'll meet not only with the parents, but I'll ask that they bring their child in as well. And so we have a conversation all together as a family to really get a better handle of exactly what's going on and what the best way is to meet those needs. And so here, that's on this slide, the powers of attorney talks about how you must have capacity to sign. Same, I don't know if anyone else has noticed this, but you can sign a power of attorney to a bank, and oftentimes you get to the bank, and maybe Bank of America or Chase or whichever bank you're using will say, we don't like this form. It's too old, or we have our own form. And so I always warn people, just because you have a power of attorney is not 100% guarantee that you're going to be able to use it in the way that you had intended. And so having guardianship in place is really the gold medal that's going to allow us to handle any situation. But if we're able to use one of these lesser restrictive alternatives, sometimes that works better. So I leave that up to the client to make that decision, and I just provide the information. There is another option. This one really has only to do with money, and that is the Social Security Administration REP Payee Program. And what that is it is the Social Security Administration is recognizing that if someone is receiving disability payments, it's for a reason. Usually it means that they're not able to make their own financial decisions. And so they will allow a family member, usually it's a parent, to be the representative payee and to manage that money on behalf of the recipient. You do have to file annual reports. And so there's some oversight of that, but not as much as in a guardianship. So I just mentioned that as an option. Special needs trusts are very similar. So if you have the means and you're looking for a way to make sure that your child has access to money once you're gone, for sure, set up a special needs trust that protects the assets from um, disqualifying your child for needs-based programs. You don't want them to lose their Social Security benefits, but they do need to be managed. And so that's something that either an attorney can help you with, or it sounds like perhaps CPG can help you as well. Let's go to the next
I
slide,
just
please.
wanted to mention on the representative payee program. So you can be a representative payee. If your child has capacity, but maybe they can't handle money, you might need a letter from the doctor indicating that they need a representative payee.
Mhm.
So it's not just, you can only be a representative payee if they're under guardianship. So I wanted to make that clear. And the other thing that I want to make very clear is the Social Security Administration does not recognize a power of attorney. They just don't. It's too bad. They don't care that you have the legal document. It's not how it works. However, there are forms, SSA 1696, where you can appoint a representative, where the individual can appoint you to be able to call on their behalf and to get information about their case. I forget that there's two forms. 1696 is one of them. I'll look up the other one and I'll put that in the chat box. But those forms are forms that you can download online and the individual can sign and you'll be able to call on their behalf. It doesn't give you the right to handle their money. You'll have to be approved as a representative payee for that. But I just wanted to mention that because we've had many people frustrated that they don't take the power of attorney. So.
Interesting. Okay. Well, thank you for that. So special needs trust we talked about just briefly. I'm not going to get into all of these details about the dollar amounts, but they are there for anybody who wants to look at the slides a little bit more closely in the future. So if we'll go ahead and skip forward to child support.
I'll just
Yep.
mention a couple of things on the ABLE account.
Mhm.
For the ABLE account, it is going up to age 46. If the disability began prior to age 46 in 2026, you can have an ABLE account. Money in the ABLE account grows tax-free and it's tax-free distributions and it won't be counted against them for Medicaid purposes. For 2025, the amount that you can contribute to an ABLE account is 19,000. And if they're working, an additional $15,060 up to their full earnings amount. So if they worked and they only made 5,000, you can contribute an additional 5,000. For 2026, the amount is $20,000 a year. And to your point, this is important. The 100,000 is disregarded for for government benefits. If there's $1 over that 100,000, then you would lose that SSI. So it is important. But an ABLE account is one place, and she's going to go deeper on the special needs trust, that you can have money above and beyond the Medicaid guidelines of $2,000 and not lose Medicaid or other public benefits. So special needs trust and ABLE accounts. Now, one other thing I want to mention on ABLE accounts, because some people will say, well, why should I get an ABLE account and a special needs trust? And it's because they work beautifully together. It's because you can pay for shelter out of an ABLE account without a 1/3 reduction to SSI. It's because an ABLE account grows tax-free and tax-free distributions, where special needs trust, the taxation of those is clearly much higher than that. And then the last thing is, when it comes to leaving assets, we cannot leave assets to an ABLE account. You can leave assets. You could make a special needs trust a beneficiary on a life insurance contract or other assets, but you cannot make an ABLE account a beneficiary on anything that you have. So that is another reason why you might need both of these accounts.
Perfect. And then same child support. Once your child turns 18, if your divorce decree or child support agreement court order says that the child support goes on indefinitely because of the disability, it's very important to make the change that those child support payments get paid directly into the special needs trust. If you do not do that, that's going to count as income to your child, now adult, and that can jeopardize the benefits that they're receiving through need-based programs. So for sure, if your child has not yet turned 18, if they're receiving child support, just check your court order and make sure that they are identified as having a disability, because if it doesn't already say in there that the child support continues indefinitely or beyond their 18th birthday, you're going to have that child support stop at 18 or high school graduation. So just double check that. I do have a lot of families come in, and at the time of the divorce or at the time of the SAPSR order, the disability may not have been known or the extent of it wasn't known. And so child support was not envisioned to continue indefinitely. And you are entitled to receive that if your child requires substantial care and is not capable of self-support. So just go back to your paperwork and double check and see what the court has said about your child support.
Before we get too far down the road, I have a couple of questions on guardianship that I wanted to ask. One person asked, how hard is it to get the guardianship removed if we figure out down the road that maybe a supported decision-making agreement and power of attorney would be appropriate now? That's the first question. I'll let you answer that, and then I'll go to the next one.
Yeah. So my thought would be to flip that upside down and say maybe start with the supported decision making agreement and power of attorney first and see how that works. And if that's not adequate, then go through the guardianship process. If it's too late, if you've already gone through the guardianship process, you can file to restore the ward's rights. It's just a separate case. You go back, just like in order to start a guardianship case, we have to bring in a certificate of medical evaluation from a doctor saying that the person is incapacitated. You go back to another doctor and they will fill out the form saying that they are no longer incapacitated. And then you go to court and ask that the disability be removed. But I would hate to go through the whole process to put a guardianship in place only to remove it again later. So definitely do some thinking on the front end and try to avoid that, because guardianship is a very time consuming and expensive process.
We've also seen both ways where they went back to have it removed and the judge didn't grant it.
Mhm.
And we've also seen where the ward's rights were restored. So we've seen it go both ways. And I also think that it depends on your county, and it depends on your judge, and it depends on the circumstances. And
Yep.
there's all kinds of things that it depends on. So I like the idea of lesser restrictive first. And if you see that that's not good enough, then you can up the ante. It's a cheaper way to go if the person has capacity. And the thing is our kids they're still learning, they're still growing, their brains aren't even fully formed until age 26. And a lot of our kids with disabilities, they're later to the party than 26. So what we see at 16 or 18 and It's not what we see at 26, 28, and what have you. So the other person is asking basically about successor guardianship. Is there a way to pass guardianship while you are alive, or the other person that is going to take the disabled person has to go through the process all over again?
Yes. So there's really two parts of every guardianship process. So the first is the court finding that the proposed ward does have a disability and is capacitated and is in need of having a guardian. So that's one half of the proceeding. The other part is who is going to be the guardian, right? We're going to qualify that person, do background checks, and make sure that they are a responsible person who can take care of the proposed ward's needs. So if something should happen, if you're getting older and you're no longer able to manage as guardian, or you have your own health issues, or you move away, whatever. If we need someone to step in as a successor guardian, you do go back to court. The new guardian does have to qualify and go through the training, take out bond, right, and be vetted. Um, but we don't have to go through the whole process of showing that the ward is still in need of guardianship. So you really only have to do that second half of the process. So it's a little bit simpler. There are documents that are part of a good estate planning package where you can nominate who takes over for you, but that's really just a way of you making your wishes clear. The probate court is not bound by that. So definitely you can pick someone if there's someone else in your family who you think would be excellent to step in for you, but there's no guarantee that the court is going to take that recommendation. They will consider it though.
Okay, so we have a few more things on guardianship that I just want to run through.
Mhm.
One person said, which is better, guardianship or durable power of attorney? And that the answer is it depends. It
You read my
depends on
mind.
capacity, right?
Yes.
So both of them can be good. It just depends on the capacity of your loved one. And again, an attorney will
Mhm.
help you figure that out. When it comes to guardianship, if we have a kid that is a threat to themselves or others or does bad things, as long as I'm not negligent as a parent, if I have guardianship, would I be held liable if they did something crazy?
No, the guardian is not liable. And also, same for financial needs. So, if your child is under guardianship and they are receiving bills for their housing, say they're living in a group home or something like that, the guardian pays those bills and manages that money, but they are not personally liable. So, there's a little bit of a distinction there.
Okay, let's see. I'm just looking for the additional guardianship ones. Um, Okay, what I want to do, I want to just address a few of the SSI and SSDI, and gosh, we do have entire webinars on that. So, SSI is supplemental security income, SSDI, Social Security Disability. They are two vastly different programs. In general, if you have more than $2,000 in your name and your child is under age 18, they're basically not going to qualify for SSI because it's based off of the parent's income and assets prior to the child turning 18. So if you've applied for SSI before, your child is under age 18 and you have been denied, it's because it's based off of your income and assets, not the child's. That changes when they turn 18. So you will want to reapply once they turn 18 after at the month following their 18th birthday is basically how that goes. SSI is an entitlement program. You do not have to pay in the system to be able to get SSI. SSDI or Social Security, we pay into that system when we work. And if the child has never worked, they've never paid into the system, but they have the ability to be covered under a parent's record when a parent either retires or goes on Social Security disability. We have entire webinars on this topic, Government Benefits 101, on the Consolidated Planning Group YouTube channel. We help people all the time know when and what to apply for, what benefits they may be eligible for, and we actually have a specialized software that tells us, it takes in the parents, all of the parents' earning years. It takes in the parent's date of birth, the child's date of birth, and it tells us exactly when and how to pull the trigger on your benefits to maximize benefits for the whole family. So we definitely do recommend that. But I just wanted to make it clear that SSI is an entitlement program, but it's truly based off of the parent's income and assets until they turn 18. Once they turn 18, even if they're under full guardianship, even if you claim them on your tax return, It's based off of their income and assets, not yours. And you want to make sure that your child does not have more than $2,000 in their name outside of an ABLE account or a special needs trust. So I just wanted to address some of those. Here's another one. And this is a good one, and it comes up. First things first, Anne, just give us a range, an average price of a non-contested guardianship. And I know you're an attorney and there's many attorneys and they all have different fees, but just give us an average price of establishing guardianship.
Gosh, so it does definitely depend, but I would say that you're looking at around $6,000 to start, and it just goes up from there, just depending on the size of your family, because different family members are required to receive notice of the proceedings. And so all of those sorts of things, if you've got a divorced set of parents or never married parents, those are all things that are going to add complications. But I would say definitely $6,000 is the low end, and it's going to go up from there.
Okay, and so one person says, how do you get guardianship without spending a lot of money? And what I would say is there are programs out there. You can go to Google and you can say legal aid services and put in your county, and the legal aid services for your county will come up and you can reach out to them. They usually work off of a sliding scale depending on your income. Sometimes it's free, sometimes it's low cost. There's also disability rights. All states have disability rights. We have Disability Rights Texas. You can check in with them. And those services are for the low income or indigent, but there are services out there, and there are various counties across the state that actually have free guardianship. Galveston County, but you have to live in Galveston County. And I think that there's some out by you. I don't remember which counties those are, Ann, but I know that there's some out your way. Do you know which county that is?
So I know that your guardianship needs to be in your home county. So if your student is in Northeast ISD, you're going to be a Bexar County resident. And unfortunately, we don't have free guardianship, but we do have two very good resources. That's the MAC Center, which is the Multi Assistance Center. If you've heard of Morgan's Wonderland, it's a part of that complex, and they do run a guardianship program for their clients. And then also Catholic Charities has a guardianship program. I know they are very busy, but they are on a sliding scale. And so that might be worth investigating if you're looking for a lower cost option to help get through the guardianship process.
Okay, perfect. All right, we're going to move on with the trust. Thank you.
Okay, so this was really just a slide to talk about the ARC of Texas Master Pooled Trust. I don't know if you have anything to add to it, Allison, but I just put it in there so that people know that that is an option instead of having a special needs trust prepared by an attorney if you are concerned about the cost of that.
I think it just depends on the amount of money that you have going to the trust. If it's a smaller amount, then I would consider a master pooled trust, whether it's the ARC of Texas or an other master pooled trust. But for the most part, the amount of money that a loved one with special needs to fund their future care is significant. And if we're planning on funding a special needs trust with significant dollars, a lot of people lean towards having their own special needs trust. It's a matter of preference. And so, and the people at the ARC of Texas are great at talking to you about their trust and how it all works.
Perfect. Okay, so there we go. So then what is guardianship? Basically, that is a process where we are notifying the court that there is an individual out there who is in need of protection, because otherwise anyone over 18 is considered an adult and they have the ability to make their own decisions without any kind of legal protection, right? Once you're 18, you can decide if you're going to get married, you can open a bank account, you can purchase a vehicle, purchase a firearm, you can vote, right? These are all things that we don't normally think about. But when you have a family member with special needs, those are all areas that are now maybe something you would want to have review over before your child goes and makes those kinds of decisions. And so by notifying the court that you have a family member who needs assistance, they will open a guardianship case. They will ask, is the person incapacitated? So on the next slide, we talk about what does it mean to be incapacitated? And what it means is that the person is not able to provide for their own food, clothing, shelter, physical health, or financial affairs. There's going to be questions on a medical form that you have filled out by a doctor that where the doctor is going to assess your child's ability to take care of those things. If it turns out that they're not able to care for themselves, we're going to skip two slides because we're zooming forward because of time. If the person is not able to care for themselves because of a disability, a mental illness, a disease, or an injury, right? Sometimes it's not an intellectual disability or autism. Sometimes it's an injury, right? I've seen people come in who've been in car accidents, motorcycle accidents, all kinds of things. And so, what we'll do is we'll assess where they are right now, and then whether it's a partial incapacity or total, right? Sometimes people need help with making medical decisions or financial decisions, but they're okay figuring out where to live, or they're able to vote, they're able to drive. It just depends. And so it's a very individualized process where the doctor's going to assess. We talk about, is guardianship appropriate? And a lot of the things that I'll use as indicators is, on the next slide, can they manage their own medication? Are they able to take care of daily living type activities? Are they picking out their clothes? Do they need help with that? Are they toileting? Are they verbal? What kind of help are they getting in school? So a student that is in a life skills program or an autistic program, usually that tells me there's more serious needs. And so we want to provide more support for them. If they're really just in like a co-teach setting and they're in their mainstream most of the time, that may be somebody who's more appropriate for the powers of attorney. Just depends, but those are some of the clues that I'm looking for. In terms of when we can file for guardianship, we can file prior to the 18th birthday, but not by much, about 6 months prior. And I would say, if you are concerned about having the guardianship on day one of adulthood, definitely start 6 months prior, because right now it's taking me at least 6 months from when I filed to get to the end of the process. And that's because there's so many steps to go through. Um, the guardian needs to go through a training process. We need to run background checks. There will be an attorney appointed to represent the youth. And that person needs to come out and do a visit and write a report on whether they recommend that the guardianship go forward or not. And so allow more time than you think you're going to need. If we finish early, we just can't have the hearing and get a signed order in place before 18th birthday. So on 18th birthday, we can go forward and have our hearing. Before that, we'll just hold off, right? If it turns out like many people come into me and it's well past the 18th birthday, we can always file for guardianship at any time. So I've done it for 20-year-olds, 30-year-olds, 40-year-olds. That's not a problem. But it does take about 6 months to get to the end.
Okay, couple of questions. Can both mom and dad be co-guardians?
Yes.
Okay. And then the question comes up of, can divorced parents be co-guardians? And I have seen that to be a yes if it is if it's a good arrangement. These terrible divorces and nobody gets along and adversarial situations is not usually granted, but the good divorce, I have seen co-guardians come out of that. Do you agree with that?
So it depends. In Bexar County, there are three different probate courts. Each have their own judge, and each judge has their own preference. What the law says is that, yes, divorced parents can be co-guardians, but what I've seen in practice is it really does depend on the co-parenting relationship. Even in a good one, I think our judges are leaning towards wanting to have a primary person, just like in child custody. It's great to have both people involved, but ultimately, when it comes down to it, they want to have one ultimate decision maker so that you're not constantly coming back into court saying, I think that our daughter should be on this medicine, but my ex-husband doesn't agree, and now we're arguing. So they're going to ultimately pick somebody to be the primary, most likely.
Okay. And if you've started the guardianship process but have not gone to a hearing yet, can you cancel it?
Yes, the case can always be non-suited. That would be an expensive decision to make, but yes, it can be.
Okay, and I've heard this one before, as the answer is no, but can a parent that has a past felony be able to be a guardian?
Probably not. Depends on what the felony is, and how old it is. So uh, it just depends. For sure, at that point, I would consult very closely with an attorney and make sure that your attorney knows all of that up front so there's no surprises.
I'll read this one. I'm not sure I understand it. Can you keep applying to services if the guardianship is removed, but the disabled party lives with them? Will the help shift? I mean, I think if you're thinking of like SSI and Medicaid and, like VR services, vocational rehab, or other kinds of things, I do believe, yeah, I mean, absolutely, you can help your loved one apply for those even if they're not under guardianship. Many parents help with those types of things. So if it looks like that was what you were asking, so thank you for clarifying that. Okay, I think we're good on questions for right now.
Okay, perfect. So then who can serve as guardian? So this is exactly what we were just mentioning. There's priority for certain people. So parents are first choice. If parents are not in a position to serve as guardian, we'll often look to adult siblings or other family members. Sometimes it will be a grandparent. Sometimes it might be a neighbor, church friend. It just kind of depends on the family tree and the circumstances. Um, for co-guardians, it is allowed if the parents are married to one another or if one of the parents is married to, say, a step parent. So mom and stepdad or dad and stepmom, that is allowed for co-guardians. Um, if you have never been married, or if you're divorced, at that point, I would say prepare yourself to be explaining to the judge or to the attorney for the proposed ward why you think you'd be a good co-guardian. They're going to ask and they're going to look into that. Also, the ward will be asked for their preference. So they're going to ask your son or daughter, do you want your mom to be your guardian, or do you want your grandma, or who? If there's some issue that's going to come up and it will be considered by the court. In terms of people who are not suitable, you do have to be an adult yourself. You cannot be in financial conflict with the proposed ward. So if I always have to ask at the final hearing, do you owe them money or do they owe you money? Usually it's not an issue, but sometimes if there have been issues in the past, that will come forward and someone will be disqualified. In terms of that felony conviction that we discussed, there are certain felonies that will disqualify you, the sexual offenses, any kind of abuse of a child or an adult. Those I would be very concerned about. Property crimes, yes, because you're now taking care of finances for the person. And so the court will not trust you to take care of someone else's money if you've demonstrated you've had trouble in the past with your own finances. And then here we go. Otherwise unsuitable if your divorced parents not working together well. I have also seen where if a child is in or a youth is in an HCS home, which is like a group home, the manager will sometimes want to become the guardian, and that's really not appropriate because one of the reasons we have a guardian is to look out for the person to make sure they're doing well and that they're being housed appropriately. And so if we put the manager of that group home in charge, who is really watching, right? They're kind of unsupervised at that point.
Couple of things. Does having guardianship limit you on waiver program to be paid as your child's caregiver? And the answer is maybe, because it depends on what Medicaid waiver the child is on. Some waivers do not pay if the child is under guardianship to a parent, but they might pay another family member in the home. So you're going to want to check with your specific waiver. There's a phone number specifically for class. The HCS, Texas Home Living, Community First Choice waivers, those are all through your LIDA, the Local Intellectual Developmental Disability Authority. That's a mouthful. The LIDA, your local LIDA is, and what is yours there? There's Bluebonnet Trails, and what's the other one?
It's ACOG here.
ACOG. Okay. So you're going to want to check with your LIDA on that and specifically the waiver that your child is on. What if your child is special ed, borderline intellectual impairment, but has significant mental health issues, walks and talks like us, but doesn't have the executive function that is necessary, non-med compliant, living with risky behaviors? Can guardianship need still be won if the ward objects because they think they're functioning fine?
Hmm. I would say in that case, I would pursue a guardianship before I would use a supported decision-making agreement because it sounds like there may not be agreement between the family and the youth. But it's difficult. We also have a mental health court here in Bexar County, and so if the primary disability is like a bipolar or schizophrenia type of illness, I would say you might find yourself in that mental health court.
Yeah, it is a slippery slope, and then some of them, like in that Again, they think they're fine, they're not med compliant. But again, usually there's a pretty strong history of non-med compliance, mental health admissions and other things like that. And it tells a story. So even if your loved one would go into the court and tell them all of the terrible things about you and why you shouldn't be the guardian and how they don't need one, the records are going to show a history and a story that no words speak. So
Yes.
I have seen cases, one in that example, and especially if they're going in and out of psychosis.
But that is the most difficult case ever because perhaps when you file the guardianship, the person may be off their meds, and then in the 6 months that it takes us to get to final hearing, perhaps we've switched medication, things have changed. If the person shows up to court and they look great, they're being very thoughtful in their comments, it may be that the guardianship is denied, and then maybe just a few weeks later they go off their medication and we start the process again. Those are very challenging and heartbreaking cases, I will say.
Thank you.
Okay, so in terms of the steps for guardianship, we'll just quickly run through. The first step is to file your application here in the probate court. Just make sure whatever attorney you use, they do need to be guardianship certified. This is a specialty, and they won't just let any attorney file these cases. You will get what's called a CME, which is the Certificate of Medical Examination form. That does need to be signed by a doctor who's licensed here in Texas. There's also an expiration date on that form, so it needs to be completed within 120 days of filing the application. So don't keep that too long once you've had it completed. It does not have to be their primary care doctor. It doesn't have to be a specialist. It's just any licensed physician. It can be a psychiatrist, it can be a medical doctor, can be neurologist, just depends. And there are specific doctors that specialize in assessing capacity and filling out CMEs. So if your regular doctor looks at that form, just doesn't know quite what to do with it, reach out to an attorney or somebody else in this field, and you can get a recommendation to someone who can fill out that form and does that on a day-to-day basis.
I heard before, and I want to just verify if this is accurate or not. And so, in that case, since we were talking about mental health crisis and issues like that, I heard before that a licensed clinical social worker is not an acceptable signature on the CME. Is that still
Correct.
the case? So, if your kid has serious mental health issues, you want to make sure that you're seeing a DO, psychiatrist, a psychologist, and not a licensed clinical social worker, because the records from them, their word, their signature doesn't work in this process. Is that still true for Texas?
That is, and I did also see a comment pop up about can a nurse practitioner sign off? And so what they've done is the newest version of the CME form does have a line where the nurse practitioner can sign, but then it needs to be also signed by a supervising physician. And so we'll have both signatures on the form.
And then the other thing that I just wanted to address here before we move on is, what if your doctor doesn't won't sign it? So we've seen this over the last couple of years where I don't know if there was a CE course or something where they said to be very careful about signing off on these CMEs. But I think it's important to take it to the doctor that has the longest and most history with your child. They know them. They have their records. Going to see a pediatrician for the first time that you just switched to and asking them to sign a CME, that's a big deal. And so, choosing, I mean, a lot of our kids have various specialists, like you were mentioning, neurologists, psychologists, psychiatrists,
Mhm.
whatever, maybe they see an oncologist or a cardiologist, whatever it is, there's a lot of doctors involved, but make sure that you're talking to the ones that truly know your child, because a person with ethics is not going to sign off on taking the rights away of someone that they don't know or understand if they have capacity.
Yeah. But if it does come down to it that your physician will not sign off on it, unfortunately, you have to find someone else. And there are doctors who specialize in this, and they will fill out that form after having met with the youth one time. That's what they do. It'll be a long morning appointment. Usually they'll be about 4 hours together, but then they do sign off on it. So those physicians do exist. What they're going to be answering on that CME, when you look at the form, there's a lot of questions on there about what is what are the capabilities of the proposed ward. And so are they oriented to time, place, situation, right? Do they know their name? Do they know where they are? Do they know what day it is or what year it is? How is their memory? Are they able to remember things? Are they communicating either orally or verbally? And then do they recognize familiar objects and persons? Those are the kinds of questions. It's a list of check boxes, and the doctor's just going to go down that list and check things off. They also are going to go over whether they can solve problems. Are they able to reason logically? Do they grasp abstract situations? Do they understand expressions, right? Figures of speech, all those kinds of things. They're just trying to gauge exactly what the level of functioning is, because an IQ number is just a number. It doesn't really tell us exactly where someone is functioning. If we can move on, I think 2 slides. One more. Perfect. And so this is where there is a difference between being fully incapacitated and partially. And then likewise, under guardianship, you can have a full guardianship or a partial. And that depends on exactly what the capabilities are of the person. And so if they are able to make some decisions, but not others, the order for guardianship will take that into account. So if they can't manage large amounts of money, maybe what they can do is have a smaller account with an ATM card. Maybe they've got a $50 limit, right? Or you could only have $500 max in that account. Those are the kinds of things that can be put into the guardianship order, because the court is looking to allow people to continue to grow. And so, how can we ever expect that our youth learn to manage money if we don't give them the opportunity? So, just be sure that we give them enough room to grow and to learn as things go on, because we might be giving this guardianship to someone that's 18 years old. They've got a long life ahead of them, and hopefully will continue to gain skills every year. Motor vehicle, this is the most common one where I see people go back on a modification. Maybe 18, 19, 20 years old, we don't trust that the youth is able to do that. But as they grow and mature, that's one that we come back to change a lot. Voting, this is a tough one. A lot of people will come back and ask for the right to vote. In terms of making a decision about getting married, I don't know. That's a case by case basis, right? And in terms of deciding where to live, even under a full guardianship, one of the rules is that the guardian is required to take into consideration what the ward wants. And so, if they want to get their own apartment and be supervised and live independently, you're required to at least consider that option if it's a possibility. Let's see. Okay. And in terms of day-to-day skills, right? Are they able to administer their own medications? Can they bathe themselves, dress themselves? These are all things that the doctor is going to ask you as they're filling out that CME, and that the court is going to consider in determining whether or not we have a full incapacity or just partial. Let's go to the next. Okay. So service, anytime a guardianship or any other case is filed, we are required to serve notice on other family members. And so if one parent is filing, the other parent is required to be served with notice. Any adult siblings. So if you're from a large family and there are a lot of children in that family now who are adults, they're going to get notice of the case, and we cannot go forward without that. If there are any powers of attorney in place already, so if you've got an older youth who's maybe tried that supported decision making agreement, if they nominated someone else to make decisions for them, we have to notify that person that we're now in probate court going forward on a guardianship. There will be an attorney appointed to represent the youth or the proposed ward. What that attorney is going to do is come out, meet with them, explain the process, and then make their own assessment of whether the youth is in need of a guardianship or not. They're also going to come to court and let the judge know if there's been any preference expressed about who should be the guardian. So they may come in and say, Judge, I've spoken to my client and they prefer that dad be their guardian, or mom be their guardian, or grandma, or whatever. But those things will be discussed. And then, just as a safety net, our probate courts here in Bexar County also employ court investigators, and they will go out and also meet with the proposed ward and talk to them, just to make sure that the disability is as described and that the ward is expressing the same preference that their attorney is saying. In terms of requirements for the guardian, you're required to take a class. It's online through the JBCC. It's about an hour long. It's free. You watch the video, take an exam at the end, and it will issue a certificate that just shows the court that you have taken this class and you're familiar with what you can and can't do as a guardian. You will also do a background check. It's not just criminal background, but also CPS, so Child Protective Services, and also Adult Protective Services. And normally you'll stop into a local chain called Identigo that does fingerprint checks as well. Also, you're required to purchase bond, which is basically like an insurance policy because now you are managing the assets of the ward. And so if you were to take that Social Security money and go to Las Vegas and lose it all, that's what the bond is for. It would make the ward whole and reimburse them for any losses.
I just wanted to talk really quick, and I know we're running out of time, but guardianship of the person, the financial assets that you can manage outside of a special needs trust and an able account is 20,000. Is that still the number for 2025?
For the bond.
As far as no, as far as managing, you can manage up to 20,000 without having
Ah,
guardianship of the estate. Because people are confused when they move here from California, where they do guardianship of the person and guardianship of the estate.
mhm.
But there isn't there a financial threshold of $20,000 to where you wouldn't need a guardianship of the estate in Texas if it's the assets are under 20,000
That's correct.
outside of an able account and special needs trust, which are excluded, right?
That's correct. And normally I'll tell people if the only income that our ward has is Social Security, then you're fine with just guardianship of the person. If there's more than that coming in on a month-to-month basis, I would say get the guardianship of the estate just to be safe. Because I would rather have guardianship of the person and the estate and not really need it than to just get of the person and need to go back again later and modify, right? Because it takes about the same amount of cost and effort to get guardianship of both than to just have the one.
Got it. And again, we're speaking for Texas. Different states do
Mhm.
things differently. So you may be in a state that in a state in the US that does both the guardianship of the person and guardianship of the estate. So I just want to make that clear. So if you're attending from another state, it doesn't mean that yours is wrong.
Yep.
So
Yep. Okay. And then just in the interest of time, I think this will be our last slide. But in order to get the guardianship signed, you do have to appear in court. You're going to testify under oath. Once you've had the hearing, you're going to sign the written oath and notarize it, and you will receive letters of guardianship. That is the proof that you have been appointed as guardianship or as guardian. And those letters expire after 16 months. Every year, you have to go back and file an annual report with the court just to let them know how the ward is doing, and if there've been any medical changes, if you've moved, if there's anything that needs to be considered, because now the court is aware that there's someone out there that needs assistance. And so just know that it's not a one and done kind of thing. You got to go every year and just provide an update and keep renewing those letters.
this is all very good information. We've got lots of slides, and everybody, as I mentioned earlier, we have more slides than what we had time to get through today, but all the information is in the slides, and you can certainly reach out to Anne at her law office and schedule a consultation with her to go deeper on any questions that we weren't able to answer today. So again, everybody's going to get a link to the recording and a copy of today's slides so you guys can look at all of that. This is just some things to keep on your special needs planning radar. We have webinars on every single one of these topics, so you can take a deeper dive on the Consolidated Planning Group YouTube channel. This link will take you to our upcoming webinars that we have scheduled, and you can register for any upcoming ones that are appropriate for the things that you're considering at this time. We work on a collaborative team here at CPG. We stand ready to help you in the planning process. This QR code will take you to our schedule where you can schedule a free personalized consultation. We'll talk to you a little bit more about the planning that you've done so far. A lot of people come to us, they've done a lot of planning, they just want a second opinion. Their advisor maybe isn't nuanced in special needs. Some people are just getting started, and some people need to pick up where they left off. And wherever you are in the process, there's no shame, no looking back. It's about moving forward. And so we'll be ready to help you when you are ready. Well, Anne, this was a great presentation, and everybody had great questions today, so I'm thankful for that. One last parting note that I wanted to leave I know there were a lot of questions on SSI and SSDI today, and I know we didn't get to all of them. But again, Government Benefits 101 on the Consolidated Planning Group YouTube channel, you'll hear everything that you need to know. But someone said, that they're having a problem of getting public benefits approved. They seem to be getting the runaround, and I just want to give you a heads up. When you apply for SSI, you should fully expect that the process is going to take at least a year. The applications are behind, they're understaffed, crazy amounts of applications. So I do suggest that you keep following up with it. There is disability determination services in Austin. They can tell you where your child's application is. You can log in and see where your child's application is and try to get it moving. But the process is slow. So don't think you apply for SSI and then the next month you're going to start getting 967 a month, because it's literally going to be a year, year and a half. One of my kids was denied 3 times and like approved at the federal level, and it went back 3.5 years. Okay, so they will go back and back pay, but it's just not a quick process. So I am sorry for that. I know it is definitely frustrating. Well, we are out of time for today, everyone. Thanks again for being here. It's certainly been our pleasure. It was wonderful partnering with you, Anne, and we will look forward to partnering with you in the future. Have a good one,
Perfect.
everyone.
All
Bye
right.
now.
Thank you. Bye bye.